This is Bloomberg Law with June Grasso from Bloomberg Radio.
What a difference a day makes. On Thursday, President-elect Donald Trump appeared at the National Cathedral, sitting with every other living president at the funeral for President Jimmy Carter.
Mr. Trump, you appear before this court today to conclude this criminal proceeding by the imposition of sentence.
But on Friday, he appeared virtually in a Manhattan courtroom to be sentenced for his criminal conviction on 34 felony counts in the hush money case. Trump addressed Judge Juan Merchan for about 6 minutes, saying he did nothing wrong and repeating familiar complaints about the case, the DA, and the weaponization of government.
I get indicted for business records. Everybody should be so accurate. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work.
The judge explained that he was giving Trump an unconditional discharge, a rare sentence which carries no prison time or penalty because of the extraordinary legal protections given to a president.
However, despite the extraordinary breadth of those protections, one power they do not provide is the power to erase a jury verdict.
Trump had tried to delay the largely symbolic sentencing with a series of rapid-fire legal challenges, including one to the Supreme Court. But they all failed, and now he'll be the first convicted felon to take office as President of the United States.
Therefore, at this time, I impose that sentence to cover all 34 counts. Sir, I wish you Godspeed as you assume your second term in office.
Joining me is litigator Dave Arenberg, former Palm Beach County State Attorney. Dave, put this historic sentencing into context.
Trump cares about his legacy deeply, and this is going to bother him. And that's why he wanted the Supreme Court to intervene even before the sentencing happens. That's not how any of this is supposed to work. The normal procedure for any other criminal defendant is you wait till after sentencing, then you appeal. But Trump wanted to be treated differently. This time he was not, and it surprised even Trump, especially when one of his appointees, Justice Amy Coney Barrett, ruled with the liberals, along with Chief Justice Roberts, to deny him his request for an appeal and an end to the sentencing, or at least a postponement until 2029. So Trump can still appeal, but he's going to go into the White House as a convicted felon.
I have to say I was surprised that he got 4 votes to stay the sentencing, even from this Supreme Court that has been friendly to him of late. They would have been extending their already controversial grant of presidential immunity from prosecution for official conduct to a president-elect.
Well, there is some ground to say that the transition period is something that is to be respected, where you want to ensure that there's nothing that would interfere with the president's transition. And here, that was a consideration for Amy Coney Barrett and for Chief Justice Roberts. But they said that because Judge Merchan said in advance that he would not give Trump any penalty, meaning he's just going to let him walk without even probation, then the level of intrusion upon the power of the presidency and the transition period is negligible. And because of that, they let it go on. But had Judge Merchan not said in advance that he would essentially let Trump walk, then I do think the Supreme Court would have stepped in, and I do think they would have put the kibosh on this sentencing. You can sort of read the writing on the wall by their one-page statement that addressed that very issue. So for those of us who believe in the rule of law, in equal justice under the law, we praise Judge Merchan for being so shrewd, smart, and savvy to make that statement in advance. It was a game changer.
Trump was treated differently from other defendants. This unconditional discharge is rare. He was convicted on 34 felonies and didn't get any kind of punishment at all. Even the delays in the sentencing, everything was because he was in this special position of running for president and now being the president-elect.
Totally. Trump supporters have said that there are 2 standards of justice in this country, and they're not wrong, but it's not in the way they think it is. It's because Trump was treated better than any other criminal defendant. The one time he was treated the same was just now with the Supreme Court, and then it was 5-4. I mean, by the skin of their nose, equal justice prevailed. But Trump was treated differently. Number one, look at the number of times he violated the court's gag order, 10 times, not given any real punishment. Think about how he was treated from the beginning in this case. Now, you can make the case that if he was not Donald Trump, that he would never have been brought up on those charges in New York, and actually you could debate that. But as far as the D.C. election interference case, as far as the Mar-a-Lago documents case, anyone would have been charged with that, and other people have been charged with those things. So Trump was treated better because the Supreme Court stepped in, put his thumb on the scale, and said, no, we're not going to let this case go forward in D.C. They knowingly delayed it so that he could not be tried before the election. And then you had Judge Cannon in South Florida, who was appointed by Donald Trump, who dismissed the whole Mar-a-Lago documents case entirely based on a strange legal theory that no other court has even recognized relating to the constitutionality of the special counsel. So, yes, I don't know how you can come up with an explanation other than he was treated differently in the system for the most part.
Trump had argued to the Supreme Court that allowing the sentencing to go forward would be a distraction to his presidential transition and that the trial was tainted by evidence that would have been barred under the new standard on presidential immunity they handed down last July. Tell us about that 5-4 decision turning Trump down.
The court said that we can deal with the problems, if any, in the New York trial after the sentencing, because that's how it's normally supposed to be done. And as far as the claim that going to New York, appearing via Zoom, having a 1-hour hearing, and not even receiving a sentence, a penalty, other than you're free to go, you're just a convicted felon from here on out, that does not intrude upon the powers of the presidency. That doesn't even detract from your transition. It's an hour out of your day. So we'll deal with this later. Now, he may ultimately succeed in overturning the New York conviction based on the immunity decision, but that would be down the line. So essentially, the court said, you may not be wrong, Mr. President-elect, but you're early.
Trump was unusually gracious about the Supreme Court's decision. He said that, I read it and I thought it was a fair decision, actually. Do you think he's looking ahead to possible appeals to the Supreme Court during the next 4 years?
Definitely. Trump is transactional. He knows the Supreme Court has unique power in this country and doesn't want to upset them in the way that he attacks other judges, especially when you have the swing justices on the Supreme Court appointed by him and the other Chief Justice Roberts, who has been moving in his direction. He's the one, after all, who wrote the immunity decision. So I don't think he wanted to go after people who he would depend on in the next 4 years to rule his way. He was playing the long game here.
Going back to things that make him different from other defendants, Trump called Justice Alito on his cell phone on Tuesday, hours before his lawyers filed their request with the court, to ask him about a former clerk who's under consideration for a job in the new administration. Alito says they didn't discuss Trump's case, but many are saying that Alito should have recused himself because of the appearance of impropriety, even if it was just the future president of the United States asking a Supreme Court justice about a job reference.
Well, the president doesn't check references for people who apply to the White House? Are you saying that, June?
I'm saying that.
It's preposterous. It just shows you why people have such a dim view of the Supreme Court. When you have a Supreme Court justice like Alito, who has flown the American flag upside down in his house, he blamed it on his wife, who has flown the flag that the January 6th insurrectionists flew, when you have someone who speaks to the president-elect on the day that a matter is filed with the court, and even if they didn't specifically talk about that matter, it is improper because Trump, as Michael Cohen said, often talks like a mob boss, where he doesn't go directly to it. He talks around a subject. Alito knows what's going on. And for him to say, no, he was just checking references. Like, doesn't he have someone underneath him to do that? Doesn't he have, staff who could do that? It just shows you how much the Supreme Court needs ethics reform. And if Chief Justice Roberts won't do it, then the reputation of the Supreme Court is going to continue to be in the sewer.
I think we know from the many motions made in this case, some of the arguments that will come up on appeal. Does he have a chance on appeal?
Like I said, it's not crazy for him to say that had he not been President Trump, then he would never have been prosecuted for it. Alvin Bragg when he was running for DA, had mentioned going after Trump. And so prosecutors need to be careful when you campaign targeting an individual. It gives grist to that individual to then claim it was a politically motivated prosecution. But keep in mind that a jury found him guilty unanimously, beyond a reasonable doubt. The evidence was strong. Now, maybe because of the Supreme Court's immunity decision, he'll get that case overturned because of the admission into evidence of Hope Hicks and Madeleine Westerhout, who are two White House employees who testified on minor matters. They were minor witnesses, but because they were included, it violated the Supreme Court's immunity decision. I think it's harmless error, and they should just let the conviction stand, but we'll see what the Supreme Court says. Mind you,
Trump walked out of the courtroom a convicted felon, but he's not, unlike other Americans, he's not going to be looking for a job where they're going to be asking him about his felony conviction. Is there any kind of repercussions for him from this?
Well, he will, other than reputational damage, have to deal with possibly losing the right to vote. That in Florida happens when you are a convicted felon. And in Florida, you can rest assured that if that does happen, then Governor DeSantis will step in and make sure that his voting rights will be immediately restored. Yet another example of Trump being treated differently than everyone else. So even though he walks free without any real repercussions, he has to deal with the matter of history. His permanent record will always reflect he's a felon unless it's overturned on appeal. And, yeah, there are potential civil rights, voting rights implications.
It's a saga that has not really ended yet. Thanks so much, Dave. That's former Palm Beach County State Attorney Dave Arenberg. Coming up next on the Bloomberg Law Show, the Supreme Court heard oral arguments on the TikTok ban today, and it seems likely the justices will uphold the ban. I'm June Grasso, and you're listening to Bloomberg. The future of the wildly popular social media platform TikTok rides on the U.S. Supreme Court. And after the oral arguments on Friday, its future looks cloudy. Under a federal law set to take effect on January 19th, TikTok will be banned in the U.S. if it isn't so by its Chinese parent company. The legal arguments pit national security against free speech, and a majority of justices suggested that national security concerns override the free speech interests of the companies and content creators. Here are Chief Justice John Roberts and Justices Brett Kavanaugh and Ketanji Brown Jackson.
So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
I think Congress and the President were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation from now will be working in the FBI or the CIA.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States?
In fact, it seemed like Justice Neil Gorsuch was the only likely vote to strike down the law, calling the government's defense of the ban paternalistic and asking why Congress couldn't just have required TikTok to post a disclaimer.
I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China.
Joining me is Matthew Schettenhelm, Bloomberg Intelligence litigation and government analyst. Matt, you're at the oral arguments. Was there one issue that dominated the 2.5 hours?
I didn't take away any one single issue other than it looked a lot like the argument at the D.C. Circuit when a majority of the justices seemed inclined to defer to Congress's decision on national security and really not that concerned that this was a major First Amendment problem for a U.S. company. And I think really focused on the idea that, hey, this is regulating ByteDance because it's located in China. And so overall, there was a sense that the justices weren't that concerned about a major change in First Amendment law because of the unique setup here, that this really was about regulating corporate structure because of the unique situation of this company.
Were there any justices who were sympathetic to the idea that the free speech rights of 170 million Americans are going to be affected if this platform shuts down?
Let me first say, I think Justice Gorsuch, is the most likely vote for TikTok on this. And he expressed a number of concerns, mostly about whether Congress had tailored its response to this issue properly, whether they are too disruptive to speech when they could have done something that didn't need to go that far. And I think he was most sympathetic to TikTok's view generally. I think there were a number of justices knowing that this decision is going to announce the law of the First Amendment going forward, and they want to be careful about how they write it. And I think because this case involves both a concern about access to U.S. data, but also concerns about propaganda, and that's where the First Amendment concerns are sort of the largest, where we're regulating content of a message. And a number of justices expressed concern about how do we address that? Should it be strict scrutiny or should it be intermediate scrutiny? I think they want to get the law right on that so that they announce the First Amendment standard properly. But I didn't read a lot of concern about ruling against the U.S. for that reason.
And what kind of scrutiny did the D.C. Circuit use in upholding the law?
So the D.C. Circuit said we're going to assume we need to apply strict scrutiny. We think it will pass any standard, but they wrote their decision assuming they had to apply the highest level of scrutiny, strict scrutiny, and they said the law passes that standard. Judge Sri Srinivasan wrote a concurrence and said, I would apply intermediate scrutiny. I don't think we need to go to strict scrutiny because this law focuses on the data security, which really doesn't raise First Amendment issues in the same way. And so for that reason, we don't need to focus on strict scrutiny. Let's do intermediate scrutiny, and this has an important justification. That's enough. I think you'll see something similar from the Supreme Court. Some justices probably will want to apply strict scrutiny. Some of them will say we should apply intermediate scrutiny. Either way, it's hard to do the math to get TikTok up to 5 justices on its side.
In the congressional hearings and in the D.C. Circuit hearings, there's been no evidence presented that China is using TikTok to spy on Americans or using Americans' data or manipulating the content. Were any of the justices concerned about this supposedly secret evidence?
Justice Gorsuch raised that most directly, and I think Chief Justice Roberts did mention it as well. And I think there was some concern, less to do with this case. It didn't seem like it was going to be a reason for the justices to overturn this decision, but it was kind of a signal to Congress and to the United States Justice Department, maybe the secret law stuff where you don't even let the other side see the evidence. Let's not keep going down that road. I think Justice Gorsuch at one point even said, hey, this might be something Congress should address, that we don't start going down the road of using secret evidence. But generally, I don't think that was really driving the court in TikTok's favor. I think there was an overall concern that, the United States has stressed this is not about hard evidence of China actually doing this. This is about avoiding the risk of China potentially doing this. And TikTok can continue to operate. It just needs to continue to operate without an owner that's located in China where this risk is at its greatest.
And what about that? That was mentioned as a possibility, but as far as I understand, China won't sell its algorithm.
That's the big hang-up, potentially. The law gives TikTok a path to continue operating if ByteDance is willing to do a sale. But there's no indication so far that ByteDance is willing to do that. And if they won't, there really aren't many options. If China is concerned about the sale of the algorithm, it's possible that there's no path forward after January 19th because the company's not willing to do a divestiture.
The idea of slapping a disclaimer on TikTok came up. Did that go very far?
As I said, Justice Gorsuch is most willing to rule for TikTok and say, look, maybe you didn't tailor this law as closely as you should have. Maybe you should have considered things that were less disruptive. I think disclosure would probably be on his list of things that Congress should have looked at first, making them maybe put a message on their screen that, hey, there's a risk of interference by China here. And the company pushed that message a lot. I didn't see, other than, as I said, Justice Gorsuch, I didn't really see it catching on with very many justices.
It is surprising to me that there wasn't more expression of real concerns, real free speech, First Amendment concerns, when this would be the first time that Congress is shutting down a platform for free speech.
Right. There were excellent briefs filed in this case, and a number of them raised exactly the point that you're making right now, that this is a novel application of U.S. law, that 170 million users expressing themselves are suddenly going to get knocked off this platform. Not suddenly. I shouldn't say that. It's not going to be a sudden death, but it is disruptive to speech in a way that U.S. law has never done before. And so there was a pretty compelling First Amendment argument to make. It just didn't get a lot of traction when you weigh the fact that Congress, on a bipartisan basis, said, look, this is a national security risk we need to address. Judges, struggle to get in the middle of that because they're not experts on national security. And so I think they were hesitant to second-guess Congress on that. I think it's going to make them struggle to rule for TikTok here.
President-elect Trump submitted a brief asking the court to put it off until he comes in. There were no constitutional arguments, but there were arguments about his being a savvy businessman who is the one who can solve this.
Right.
So what about the possibility of the court issuing a stay of the effective date?
That came up directly. I think Justice Kavanaugh at one point asked about it. And I think the Solicitor General's point was the only way to do that. As you said, President Trump didn't address the legal standard to do that. But the legal standard really runs to, is TikTok likely to win this case? And as we've talked about, TikTok is not likely to win this case. So if you're applying that legal standard, the test for issuing a stay of a deadline that Congress set is not that President Trump has a warm spot in his heart for a company and would like it that way. It is whether the company is likely to prevail because this violates the law. And I don't see any way that 5 Supreme Court justices are going to say that TikTok is likely to succeed on that argument. So for that reason, a stay doesn't really make sense. They don't issue stays just because the next administration wishes Congress had set a different date.
If the court rules against TikTok, as we now expect after these oral arguments, is there any hope for TikTok?
So it's going to get really interesting there because of what President Trump has said. So if I'm a company that hosts TikTok and this law takes effect on January 19th, I am very concerned about accruing substantial liability on that day. The law subjects those companies to $5,000 per user. And as we said, 170 million users in the United States. The math is astronomical in terms of the potential liability for hosting TikTok on January 19th, which is before President Trump takes office. So I think there's real risk for those companies to continue hosting TikTok. It's possible President Trump comes in and says, don't worry about that law. I'm not going to enforce it. But if you're a company facing the accrual of that much liability, are you willing to take that chance? Are you willing to potentially give him leverage over your company if he wants to change his mind? Do you want to litigate over whether that would violate due process for him to change his mind? I don't think so. That's a big dollar amount. So the best path forward for TikTok would be convincing Congress to reverse itself and maybe getting President Trump to push that idea or some alternative, have Congress pass a new law. But short of that, it's really hard to see a path forward.
It does look quite bleak for TikTok, and we should get a decision on this from the Supreme Court next week before the TikTok ban goes into effect on January 19th. Thanks so much, Matt. That's Bloomberg Intelligence litigation and government analyst Matthew Schettenhelm. Coming up next on the Bloomberg Law Show, Nippon Steel and U.S. Steel are suing the Biden administration in a last-ditch effort to save their merger. I'm June Grasso, and you're listening to Bloomberg. Nippon Steel is standing firm on its plans to acquire U.S. Steel, with both companies suing the Biden administration this week in a last-ditch effort to save the $15 billion merger. President Biden blocked the deal, citing a risk to national security. But the companies say the review by the Committee on Foreign Investment in the United States was a sham, and that Biden blocked the deal for purely political reasons. That is, to gain favor with union steelworkers in Pennsylvania in his re-election bid. The president had announced his opposition to the deal in March, before the CFIUS review even began. And in April, at the U.S. Steel headquarters in Pittsburgh, Biden made this promise to the union workers.
U.S. Steel has been an iconic American company for more than a century, and it should remain a totally American company. American owned, American operated by American union steelworkers, the best in the world. And that's going to happen, I promise you.
Joining me is John Cabillo, a Washington, D.C. attorney who specializes in cross-border transactions. John, since 1990, only 8 other foreign transactions have been blocked by presidents, according to the Congressional Research Service. And here President Biden reportedly went against his top national security aides in blocking the sale to a Japanese company, even though Japan is a long-standing ally of our country.
Right. It is extraordinarily rare for a president to formally block any investment via CFIUS. I think it's unprecedented that a president would block a transaction like this, an investment coming from an allied nation, a critical allied nation, and in particular where there's no clear national security threat posed by the investment.
I'm confused about what Biden says is a national security threat. Is it a national security threat as, the average person might see it, or is it a threat to the domestic steel industry?
That's a great question. And part of that gets at the evolution of CFIUS over the years. 10, 15, 20 years ago, things that were thought of as quote-unquote national security issues, that really was a limited set of things, and it related to weapons systems and telecommunications networks and big, pretty clearly strategic assets in the United States. It is true that the notion of national security has expanded some over time, and now it includes things like the personal data of U.S. citizens. Certainly software and things like that have been lumped into this concept of things that can cause national security concerns. Steel itself obviously is useful to the military, but there's no evidence that in this transaction, Nippon Steel was going to do anything other than expand production in the United States and bring more investment and, frankly, better steelmaking technology into the United States. So it's hard to say that there's any sort of threat to steelmaking in the United States because of the transaction. And ultimately, it looks like it boils down to just kind of a U.S.-centric notion that this company, that's an iconic company in the United States, it should be owned by U.S. persons and not owned by a foreign company. And that's really not at all what CFIUS was set up to do. And so what we're looking at is the president is sort of abusing his authorities under CFIUS to achieve a political outcome.
That sort of echoes some of the claims the steel companies are making in their lawsuit that argues that Biden violated the Constitution in blocking the merger. Tell us more about their arguments.
So CFIUS is an authority. It's under the Defense Production Act of 1950, and its authorities were just expanded recently in 2018. But really what the law says is that, first and foremost, the U.S. is intended to have an open investment environment that allows foreign direct investment into the United States. And what CFIUS is empowered to do is review investments from foreign parties. CFIUS has the ability to approve those transactions, but if a transaction may pose a threat to the U.S. national security, then CFIUS can negotiate conditions and require an investor to comply with whatever conditions it needs before it approves the transaction. Only in the rarest of circumstances, if there's a threat that is so great and CFIUS can't find a way to solve the threat, then it goes to the president, and the president has the authority to block the transaction. With that as background, what the lawsuit essentially is saying is that the process and the requirements necessary for a president to block the transaction were never followed. Before CFIUS even began to review the transaction, President Biden, Vice President Harris, and Secretary Yellen had already gone public saying that the transaction should not go through, that U.S. Steel needed to remain domestically owned, and Biden even told the steelworkers that he guaranteed that the transaction was not going to go through. And again, this is before the CFIUS process had started. I think fundamentally shows that they had no intention of sort of looking at the facts or following the requirements of the law. They had essentially looked at the transaction and knew that it was a political hot potato and were currying favor with voters in a swing state by saying, we're never going to let this go forward. But that's not what the law allows the president to do.
The steel companies say that the CFIUS panel sent a 17-page letter of security concerns riddled with inaccuracies over the Labor Day weekend and only gave them one business day to respond. And they claim that the CFIUS staff were told not to offer counterproposals or engage in discussions. That on its face, if true, seems to support the steel company's arguments.
I think that's right. And I think it's important to draw out that distinction, which is that the president did this to Nippon Steel and U.S. Steel, and the president also did this to CFIUS itself. I think the career staff at CFIUS, they are quite good at running their process. And so when you see things like a 17-page letter that, again, allegedly was riddled with factual inaccuracies, that's not the type of thing that you would ordinarily see out of CFIUS. And I think it would show you that CFIUS was being ordered to do something that it really didn't have evidence or justification to do. And so they were sort of put in a position where they had to stretch to meet the directive from above.
Presidents have broad authority to determine what constitutes a national security threat. Can the president's authority here be challenged successfully in court?
This is the novel issue here, which is, courts historically for centuries have deferred to the president on questions of national security, the substantive decision-making regarding what counts as a national security threat and what does not. So in that regard, the president does have broad authorities, and it's hard to challenge them. But here, I think what the parties are saying is that the process itself was so flawed, they were denied their rights from the beginning. And ultimately, what the president was doing was not making a national security determination. What the president was doing was making a political determination. And so I think that's the really interesting issue, at least in my mind, that the courts are going to have to consider is, when a president pretty clearly is engaged in political behavior, but just claiming that it's national security decision-making, what degree of deference does a court have to give the president in those situations? And I think that's a nuanced and a novel question, and one where I think the parties may have more traction than if it were, pretty clearly a standard national security type decision that maybe the parties didn't like, or maybe they thought that the president was going too far. But I don't even think there was really much of an attempt to call this, national security. This was economic nationalism. This was election year politics. This was all sorts of things, but it was not national security.
The companies here are basically making a due process argument. And nearly a decade ago, there was a court challenge to the CFIUS review process and the president's authority over foreign business deals. That concerned a Chinese-owned company, and a federal appeals court ruled that the company's due process rights were violated by the CFIUS review. But still, the court didn't overturn President Barack Obama's order that the Chinese company had to sell. Does that case have relevance here?
Right. That was a little different. I think that case is instructive in that, first of all, due process challenges can be successful when the CFIUS process itself is corrupted. And so in that case, CFIUS pursued an action against a Chinese acquirer of wind farms that were next to military airspace that was used to train unmanned aerial vehicles. And CFIUS issued an interim order very early in the process, and they ordered the deconstruction of windmills. They ordered that the acquirer not access the property. They ordered all sorts of extremely onerous things. And what the parties argued there was that essentially the order from CFIUS was so onerous that it was equivalent to blocking the transaction. And really only the president of the United States has the authority to block a transaction. And so I think they got a lot of traction on that angle, which was that there are limitations to what CFIUS as a committee can do. And then additionally, they got some traction on the notion that CFIUS does have to provide some information about its decision-making process when it's going to take an adverse action against the party. And then, again, when that process was rerun and when the decision was in Obama's hands, there was not a substantive way to challenge a president's decision on national security grounds, but the parties did make a lot of progress on the procedural violations.
So do you think it's possible that a court would order another review by CFIUS here?
Yeah, I think it's possible that a court would order another review. It's clear that the process was corrupted from even before day one. And so in that regard, whatever sort of the maximal remedy for due process violations is, any court should provide that remedy. And then I think the next question, which is, okay, there's going to be a new administration in town. The next president has come out against this transaction. What happens there? And this is just sort of crystal ball talk here, but I do think that the parties are presented with an opportunity to actually reach some kind of a deal with the new administration. When you look at all of the commitments that Nippon Steel was willing to make to get the deal done, I think ultimately that transaction was really, really good for the steelworkers and for U.S. Steel and for our domestic steel industry and for our supply chain security. I think that the parties may well be able to make a compelling pitch to the next administration and find a way to get a deal done. The next administration, I think they pride themselves in finding ways to get deals done. And I think when they look at what's being offered, they may find something very compelling in that.
And if all else fails, might a cert petition to the Supreme Court be ahead?
There are some novel legal questions here that I would love to see in the hands of the Supreme Court, because I think it's really critical, really, really critical, not just for the CFIUS process and not just for transaction parties, but I really think for everyone, it's important that we come up with some idea that no president can just, wave a wand and call something national security and then be exempt from all scrutiny. More and more things are being called national security, and at some point, we have to have some guardrails.
Thanks so much for joining me on the show, John. That's John Cabilo, who specializes in cross-border transactions. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.